The Court of Disputed Returns should not reward negligence by letting off parliamentarians who did not take reasonable steps to investigate their dual citizenship, the lawyer for Greens Larissa Waters and Scott Ludlam has argued. In the second day of eligibility hearings on Wednesday, Brian Walters argued the court should reject the Commonwealth's less strict interpretation that parliamentarians without knowledge of their dual citizenship are eligible because they did not voluntarily obtain or retain allegiance to a foreign power. Walters argued that the country of one's birth and one's parents' citizenship constituted primary facts that should prompt inquiries about one's citizenship. Once aspiring parliamentarians had such facts and wanted to nominate for election, they have a duty not only to be honest but to be careful, he said. Negligence in complying with one's constitutional obligations should never produce a better result than diligence, he said, proposing a test of whether parliamentarians had taken reasonable steps to ascertain their foreign citizenship. But the Greens' proposed test was immediately doubted by the Chief Justice, Susan Kiefel. Kiefel questioned how the case could work backwards from the conclusion in Sykes v. Cleary that parliamentarians had to take reasonable steps to renounce foreign citizenship to extend it to a new requirement that they had to take reasonable steps to discover their dual citizenship. "I don't know how you get there," she said. Walters argued that Section 44 was designed not only to prevent parliamentarians holding split allegiances to foreign powers but also to remove perceptions of divided loyalty and enhance Australians' confidence in its parliament. He said the section should be understood as an assertion of Australian sovereignty, that government of Australians will be only by Australians. Repeated questioning from the bench suggested that such a reading was consistent with a disqualification of all foreign citizens but did not support the reasonable steps test. Walters conceded that his own clients did not take reasonable steps to investigate their citizenship because Ludlam, who was naturalised as an Australian at age 19, knew he was New Zealander before that, and Waters, who was born in Canada but left at 11 months of age, did not investigate whether she was Canadian. Section 44 of the Commonwealth Constitution states that people are incapable of being chosen as a senator or MP if they are the subject or citizen of a foreign power. On Tuesday, Barnaby Joyce and Fiona Nash's counsel, Brett Walker, submitted that people could not have allegiance to a foreign power if they did not know about their dual citizenship. On Wednesday, the former Solicitor General Justin Gleeson, on behalf of the former independent MP Tony Windsor, rejected that, arguing allegiance derives from one's status as a foreign citizen regardless of whether one is aware of it. He gave the example of a dual Greek-Australian citizen conscripted into military service in Greece despite ignorance of their foreign citizenship. Gleeson submitted that the ordinary way to fix having dual citizenship is to renounce it before nominating for Parliament. He said the exceptions to the general rule that dual citizens are ineligible are limited to exorbitant foreign laws or those that threaten Australia representative democracy, such as if a foreign power practically refused to allow Australians to renounce their dual citizenship. Earlier, Matt Canavan's lawyer warned a strict interpretation of the disqualification of parliamentarians with dual citizenship would lead to genealogical witch hunts by political opponents. David Bennett argued that citizenship by descent passing down through multiple generations was an exorbitant law that would disqualify politicians with a slender connection to a foreign power. Bennett said that if the court recognized indefinite citizenship by descent as a disqualification, it would give rise to offensive inquiries about whether a person were 1/4, 1/8 or 1/16 foreign, which was inappropriate in an immigrant nation. In Wednesday's hearing, Nick Xenophon's counsel, Andrew Talkley, argued that his British overseas citizenship did not include the core features of citizenship, the ability to enter and reside in Britain, and thus should not be a bar to eligibility. The hearing continues.